Good afternoon, everyone, and welcome to the first installment of the Udo and Belo-Osagie 2021 HICE September series. I'll be invited. My name is Adiola Sumola, and I am a partner in EUBO's Banking and Finance and Compliance and Investigation team. We will be starting today's session by inviting our firm's managing partner, Mr. Anikan Ukwana, to provide opening remarks in relation to our HICE September series 2021. Mr. Ukwana, over to you.
Thank you, Adiola, and I'm hoping that you will introduce the panelists after my opening remarks.
Yes, I will do that.
Good morning, good afternoon, good evening, wherever you may be. Welcome to the EUBO HICE Summit. EUBO has created a niche for itself in keeping both its clients and network informed on key regulatory changes, as well as stimulating thought-provoking discussions on contemporary legal issues in Nigeria. Our firm does this through various knowledge sharing and capacity building initiatives. And the annual investigation, compliance, and ethics HICE Summit is one of such initiatives. EUBO has been hosting the HICE Summit since 2018. The theme for this year's HICE Summit is the new norm. And in line with this theme, the focus will be on addressing the changes that have been necessitated in the wake of the COVID-19 pandemic, as well as its impact on regulatory landscape. The HICE Summit will comprise 4 sessions addressing various topical issues in relation to investigation and compliance practice. One of these sessions will be a regulatory masterclass solely for regulators and will cover progressive approaches in ensuring compliance with laws and regulations. The first session starts this afternoon, and the other 3 sessions will hold on the 21st, 28th, and 29th of this month. The first session, which will commence shortly, will focus on internal investigations, consequences for corporate reputation, and best practices. In this session, we will be discussing best practices for conducting internal investigations post-COVID-19, recent trends, and strategies for dealing with infractions. The second session is titled New Landscape for Corporate Policies. At this session, discussions will revolve around key corporate policies and how the corporate policy landscape has been impacted by recent happenings. At the third session, focus will be on ESG for corporates, trends, challenges, and horizons. This session will explore ESG requirements for corporate entities in different jurisdictions and hopefully give our panelists an opportunity to share their insights, ideas, and experiences on global ESG trends and the challenges which corporate entities will face while aiming for compliance. At the fourth and final session, the HICE Summit will end with a regulatory masterclass, which is aimed at enhancing regulatory compliance in a global marketplace. At this session, our focus will be on engaging with and addressing issues from the standpoint of the regulators. This session will seek to encourage a discourse amongst regulators as to progressive approaches in ensuring compliance with law and regulations. That pretty much wraps up my opening remarks, and I think that I don't want to take much of your time. So on this note, on behalf of the EUBO team, I am delighted to welcome you to this year's HICE Summit, which we now proudly call our September series. And I hope that it will be a fulfilling, enlightening, and thought-provoking experience for all our speakers and the audience. Once again, thank you and welcome.
Thank you, Mr. Ukwana, for your opening remarks. As I said, I am the moderator of today's session, and I have with me a number of panelists from different jurisdictions, from South Africa to Nigeria and the United Kingdom. Our session today, we will be discussing internal investigations, consequences for corporate reputation, and best practices. At this session, we'll seek to discuss best practices for conducting internal investigations post-COVID-19 and the new norm, particularly given the increasing level of remote work policies by different organizations. I would be delighted to introduce each of our panelists, but I would ask them to speak briefly about their practice and what they do. With us on today's session, I have my partner, Olukayode Dada. I also have Cameron Dunstan-Smith, who's a director at Ebersmith Freehills. I also have Katie Palms, who's a counsel at Freshfields. And last but not the least, I've got Ben Haley, who's a partner and leads the African practice of the compliance and investigations team at Covington and Berlin. Thank you all for joining us this afternoon. And I would like each of you to start by introducing yourselves, by telling us what it is that you do within the compliance and investigation space, and we can continue the conversation from there. But just before we do that, I'd like to quickly run through the short agenda that we have for today's session. After our introductions, we'll go straight into the panel discussion, and thereafter we'll take questions for about 10 minutes. And then we will close with each of you with your respective closing remarks, whilst I'll do a wrap up. So let's get started. And I'd like to ask Katie to introduce herself.
Thank you very much, Adiola. Nice to see all of you. Nice to be here with all of you. Thanks for the invitation and for hosting. My name is Katie Palms. I'm counsel in Freshfields Investigations and Disputes team. And I specialize in global investigations and compliance and have been practicing in this area for about 10 years. I'm currently based in London, but I actually started my career with Freshfields in New York. And so I've had the fantastic opportunity to work closely with clients on both internal and external investigations and compliance matters from and in both places. But my practice doesn't just involve the US and UK. As you might imagine, I work on investigations and compliance mandates across the globe in many different countries. I did a sort of quick dip test ahead of this session to see what countries I had worked on investigations and compliance matters with in the last 18 months of the pandemic, including Hungary, Canada, India, Germany, Niger, Belgium, Belarus, Senegal, Chile, Singapore, Egypt, Spain, Turkey, in addition to the UK and US, and I'm sure my colleagues would say many more. So truly a global practice, and therefore really thrilled to be with all of you today, speaking about this very apt and well-timed topic.
Thank you for joining us, Katie. You're next, Cameron.
Thanks, Adiola. Nice to see you again. So I'm Cameron Dunstan-Smith, and I'm a director at Herbert Smith Freehills in Johannesburg. I lead the corporate crime and investigations practice for the South African office at Herbert Smith. And I've been in this game for about 15 years. So cover the sort of full spectrum of whatever comes to the door, really. And in Africa, as you know, there's a lot of it. So it's all your typical fraud and corruption, ABC compliance, internal investigations, regulatory investigations, etc. So it's a fun place to be, and it's certainly a growing industry. I think when I sort of got into this industry 15 years ago, it was a much smaller sort of group than it is now, and it's a much bigger industry in South Africa. And I think we're following the lead globally, and in Africa, it's a burgeoning sort of practice as well. So it's great to sort of have seen the evolution of the investigation space in Africa. And in terms of jurisdictions that I've been involved in, I think I used to get up and have coffee and dinner with Adiola a lot more often than I do now, since COVID. But I wouldn't say that's impacted similarly to Katie. In some respects, I think it's actually increased the ability to work on cross-border matters. Just because the virtual piece means you can pull in resources from everywhere, and I found that at our firm it's been, and I'm sure it's the same at Freshfields and Covington as well. It's been quite refreshing to collaborate more with other offices and stuff. So the from a jurisdictional point of view, I think it's actually grown more than sort of been a limit, which is a kind of strange. You wouldn't have thought this 18 months ago, but I think that's where we are now.
Okay, thank you, Cameron. Ben?
Thanks, Adiola. My name is Ben Haley. I'm a partner in Covington and Burling's white collar and investigations and anti-corruption practices. I'm based in Johannesburg. I'm actually right down the road from Cameron. So, but I'm as you can tell by my accent, I'm a U.S. lawyer. I grew up in Covington's white collar practice in the United States. Spend a lot of time on matters in front of the U.S. Department of Justice and the Securities and Exchange Commission on Foreign Corrupt Practices Act matters and other matters. In Africa, I have a split practice between compliance and investigations and advisory matters from the range of investment transactions to compliance program assessments and risk assessments and more proactive work. Delighted to have the opportunity to reconnect with my friends at Udo Adoma. I think back to the time back in 2016 when I arrived in your offices fresh off a trip to Port Harcourt, Elisha, and Onitsha to meet you with open arms back in Lagos on dry land again. So we've had the pleasure to work with your firm over the years. Have been really our preferred partner on all things compliance and commercial related in Nigeria. It's been a wonderful partnership. Right now, since we did the around the world, I have a less impressive but local list of African countries that I'm working on right now, and some mining deals in DRC, some interesting transactions in Mozambique and Zimbabwe. And my practice is also I do work outside of Africa and other emerging markets, so I'm still busy in matters in Russia, busy in matters in Israel as well. So take advantage of the time zone here to work the entire EMEA area. But really delighted to be here today with this great panel, and thanks for the opportunity.
You're welcome, Ben, and thank you for joining us. Olukayode.
Okay, so thank you, Adiola. So I'm a partner in Dodoma's risk resolution and compliance and investigations teams. I specialize in litigation, white collar crimes, ethics and compliance, anti-corruption, anti-money laundering, terrorist financing laws. I also do a bit of cybersecurity law. So I have experience in conducting internal investigations and other ethics-related investigations, and conducting general criminal background checks for ongoing or potential business relationships. In recent times, our work has involved cross-border investigations, particularly in partnership with our friends in the UK, in the US, and across the other jurisdictions. So that's what I do.
Thank you, Olukayode, and thanks to all of you. I'd introduced myself before, but again, my name is Adiola Sumola, and I am a partner in Udo and Belo-Osagie's Banking and Finance and Compliance and Investigations team. I've been working at UUBO for about 15 years now. So I get to brag about the length of years as well. I don't want it to be just Cameron that'll be doing that. We'll go straight into our discussion now, and I'd like to start by setting the tone of the conversation by having each of you briefly tell us the current level of compliance and enforcement activities in your respective jurisdictions, as well as in the countries where your clients are active. How do you think the current level of activity compares with the last 18 months? I don't think I need to overflog what's been happening all over the world in the last 18 months, but it'll be good to hear your insights on how the current level of compliance activity has panned out in the past year and a half. So I'd like to start with Cameron, if that's okay. Cameron.
Sure. So, I mean, I'd be interested in Ben and Olukoye's and Katie's views, but from my perspective, I think we were all a little bit concerned at the beginning that sort of compliance would fall by the wayside and everyone sort of focusing on the other issues associated with the pandemic. But I've seen that hasn't really been the case in my experience. We haven't had any shortage of, we haven't seen a downturn in the type of work that's coming in. So people are as active, and I think it's probably not just in the compliance space. People realize globally in whatever space you're in that you have to keep moving forward. We're going to be stuck in this sort of new normal for a while, and I think everyone's just adapted. So I would say that there has been a steady sort of flow of typical compliance practices that are going on. Some of my clients have, particularly the financial institutions, have said that they've actually got more work than they had before, and they're feeling a little bit overloaded. So in some instances, I think there's actually been an increase. So from thinking that there would be a sort of downturn, I actually haven't seen that. I know we've been dealing with the SEC on a matter in the US with my colleagues in New York, but it's an African matter that I'm working on. And I know initially the SEC were a little slow in sort of conducting investigations, and they put those things on the back burner for a while. But they eventually sort of found a way to do it and got comfortable, doing virtual interviews and depositions, etc. So I think that has sort of, the ship has righted in that respect, and it's carrying on. At a local level, in South Africa, we're seeing, again, we don't have a great track record of enforcement. So I think the compliance issues that we're dealing with are either at an internal organizational level or foreign regulators like the SFO or the SEC or DOJ, sort of looking at things as opposed to enforcement down here. The one thing, and Ben will probably touch on it as well, is we've had a lot of attention in this jurisdiction on corruption for going on 3 years now, with a very large commission of inquiry, which is one of a number of judicial commissions of inquiry into various maladministration, fraud and corruption at the government level. And so there's just been this huge outpouring of not necessarily enforcement activity, but certainly awareness and exposure of corruption and other things that have been happening. We've had a couple of really big sort of regulatory issues relating to some financial institutions and other companies that have misstated financial records and that type of thing, and shareholders have been abused, and so those types of things have sort of been the headline issues. So I would say that while there's been a lot of attention, just because of where we are and the sort of, I would put it down to an inability or undercapacity to take proper enforcement action at a local level. Enforcement activity is not possibly where it should be, but I certainly think the attention and sort of coverage that these compliance, corruption, ethics issues are getting has never been higher from a South African perspective. Sorry, Adiola, you're on mute.
Yes, indeed. I was just calling you, Ben. I was asking you to to share your thoughts on recent development.
Yeah, no, I think the on state capture, to pick up on what Cameron referred to here, the sort of really interesting point for me is that we have this reckoning that the South African government is doing with historical issues of bribery and corruption, and obviously they're not the only regulator enforcement authority in the picture there. The U.S. is involved there, and other regulators are in the picture as well. But at the same time, if you look around the continent, you see massive big corruption scandals that the U.S. has a piece of in terms of investigations or trials. You have the Mozambique tuna bonds case. We have Luanda leaks in Angola. You have an ongoing investigation relating to Glencore that I'm sure that some in Nigeria picked up on, because there was a pretty significant NNPC angle there. And then we have we have this sort of drumbeat of smaller matters that come up day to day. I think from the U.S. standpoint, we would say that enforcement was probably relatively muted during the Trump administration, but we really expect that in the Biden administration that will continue to pick up. And one really notable point there is that the Biden administration has identified the fight against global corruption and kleptocracy as a core national security interest. So the alignment of U.S. Interests in the world together with the anti-corruption agenda is something that I think is really important. And I think that you will see resources be put behind making those big cases around the world. And the U.S. has a real interest in infrastructure in Africa, in U.S. companies and international companies investing in Africa, in ensuring that in places like the DRC, for example, that where there are really important minerals to the energy transition, that corruption does not keep U.S. companies from going into markets like that. So I think that not only are we looking at the sort of focus on enforcement, but broader policy levers that the Biden administration can push and pull to help companies, U.S. companies that are trying to do business ethically in Africa, operate on the ground here. So I think that if we look at the pipeline in a few years, we will see a robust number of cases that come out of this this period of 18 months. I also think the other piece, and I don't want to sort of preview too much, but I do think that the sort of circumstances of the pandemic do create systemic corruption risks, right? Because they cause the shutdown of government, they cause bottlenecks in customs, bottlenecks in licensing and permitting. They cause employees to be in a position of needing or wanting to take shortcuts because they're feeling immense business pressures. And so I think, and Cameron can probably speak to this better than I can, but here in South Africa, we saw massive amounts of fraud around PPE tenders, right? And so the type of procurement that governments have had to do on an emergency basis creates rent seeking, and it creates opportunists, and creates so-called tenderpreneurs. And so, we do see direct effects and creating of different types of compliance risks. And so one of the things that we always tell our clients in this circumstance is that you have to sort of do your risk assessment to the circumstances that are around you right now, and look at exactly what is happening in your business and the increases in risk that come from things around the pandemic. Not just how hard it is to do investigations during the pandemic, but how do employees make good or bad decisions when they're faced with these types of unprecedented business pressures. So that's
thank you, Ben. Katie?
Sure.
Picking up on I guess, and melding two of the themes that Cameron and Ben have talked about in terms of the level of internal compliance activity. I completely agree with what Cameron said, that, although we sort of feared that there would be a downtick, actually, I think levels of compliance, internal compliance enforcement and attention really have been very high throughout. And I would echo, though, that they maybe have been directed towards different types of activity. And one of the points that I've anyway noticed is sort of a different focus, is perhaps an increased focus on due diligence and sort of that aspect of, either in the acquisition context or the investment context. There's a lot of, understandably, a lot of change and transformation as businesses try to weather the pandemic, to change the business model during the pandemic. A lot of investments in different kinds of companies, frankly, a lot of investments and expansion of desk-based virtual e-finance types of companies that allow people to work and live remotely during this period of time. those types of businesses carry compliance risk, whether you are the business yourself or whether you're investing in them or financing them or what have you. And so I think we've seen a very heavy investment in sort of doing appropriate compliance and ethics due diligence in those sorts of transactions, possibly to even a higher level generally than I would have said before the pandemic. And secondly, as I say, sort of a different focus, not only on the COVID specific risks, as Ben was talking about, sort of trying to make sure that to the extent you can, you're figuring out whether there's anything in that entity that occurred, any misconduct that occurred during the pandemic, COVID relief, fraud, that sort of thing, but also just trying to understand what the new risk landscape is of those entities. And from a UK perspective, possibly a slight shift away from bribery, qua bribery, and more towards a money laundering, sort of how do you handle the proceeds of crime? When is that going to come into the picture? When do you have to worry about that? When could that be enforced? Because the statutes here, I like to think about it as almost the inverse of the US, right? Whereas if in the US it's going to be a bribery foot forward from a regulatory perspective, with money laundering following, sometimes in the UK it's somewhat the opposite with, the breadth of POCA, the money laundering legislation here being so broad, so extraterritorial, with potentially the Bribery Act following behind. So sort of overall message is that a lot of internal compliance activity, and possibly of a different nature during the pandemic, but certainly a focus. Just a very quick comment on the external landscape. I think the dip in the UK was possibly lower than in the US during the pandemic. It's no secret that it was relatively quiet, particularly during the first 6 months. But equally, we are definitely experiencing an uptick now in enforcement activity and attention and predictions that that's going to continue. There was a DPA, a headline DPA in July, resolution of entering into a deferred prosecution agreement by the SFO, including in relation to some historical conduct in Nigeria. So, that's just one data point, but I think many people are predicting that trend will continue as we move forward out of the sort of the deepest valley of the pandemic.
Thank you. Olukayode, can you briefly share with us your thoughts on recent developments and how active we've been in the past year and a half?
Okay, so compared to the previous years, there has been increase in compliance and enforcement in Nigeria, particularly from a regulatory standpoint. The regulators, the Economic and Financial Crimes Commission, the Federal Competition and Consumer Protection Commission, that's the FCCPC, appear to have stepped up enforcement activities in recent times. And in fact, they have utilized dawn rates more to achieve their enforcement objectives. Sometime in March this year, the FCCPC promulgated a rule that they call the Cooperation and Assistance Rules and Procedures 2021, which in essence is to facilitate settlement of regulatory issues with companies that the FCCPC is investigating. Now, so it appears that clients are more concerned with compliance issues arising from competition law in Nigeria than before. No, these issues range from consumer protection issues to what the competition calls anti-competitive practices, competition practices, and also issues arising from approvals for mergers and acquisition. Now, earlier this year, the Lagos State government promulgated what is called the Lagos State Public Complaints and Anti-Corruption Law 2021. That came into force on 19th April 2021, essentially establishing a Lagos State Anti-Corruption Agency tasked with investigating and prosecuting corruption arising within Lagos State, particularly from government agencies. And so that is essentially what what's happened in the past 18 months or so in Nigeria.
Thank you. Thank you, Olukayode. My next question is for Ben, and I'd like Ben to share his thoughts with us on, oftentimes, Ben, it's an internal investigation is the aftermath of either a done raid or a regulatory investigation, or even whistleblowing by an employee in an organization. So I'd like you to share your thoughts with us on how you think an institution should approach an internal investigation after any of these triggers. How often or how soon should a company undertake an internal investigation following any of these triggers? And what's the most efficient process that's underscored by best practices?
Sure, it's a good one. So I think that the answer is in those three triggers, it's probably 99% of the time, the answer is immediately. I think it's usually necessary for a company to initiate some sort of internal investigation in response to a dawn raid or a regulatory inquiry or investigation. Whistleblowing, I think usually companies will employ some sort of triaging at the outset to understand the nature and extent of the allegations and whether the allegations have any credibility to them. But in the other two instances, I would think most of the time companies are going to want to undertake some sort of an internal investigation. And I think in all those circumstances, it's going to be in the company's best interest to get out ahead of what other allegations or questions are out there. That's going to enable the company to be better positioned to respond to inquiries from regulators, to manage reputational, other collateral risk, but also to take remedial actions to stop whatever conduct is ongoing, if there is misconduct ongoing. In the case of regulatory investigations in particular, and this is, I'm really focused on the US law investigations, but if the company is seeking mitigation credit in an enforcement action, right, it's seeking to get a better resolution in a DPA or a non-prosecution agreement or whatever resolution it has. It could be trying to get a declination. A regulator will typically be assessing the degree to which the company has cooperated in the investigation and remediated the misconduct. That is, if the company hasn't made an affirmative voluntary disclosure. So if the company wants that mitigation credit from the US DOJ, it really needs to consider the expectations that DOJ has spelled out in various guidance. And this turns to the best practices question, Adiola. What specifically DOJ expects, that's a longer discussion, but in summary, I would hit on three really important points. And the first is that DOJ expects companies to promptly preserve and collect relevant documents and information as quickly as possible after learning the conduct at issue. We have sort of a saying here in terms of preservation of documents is that once it's gone, it's gone. And if you don't have the ability to convince a regulator or an external stakeholder like an auditor that you've taken those steps to preserve the factual record around the wrongdoing, then it can crater the credibility of your entire investigation, because a regulator or external stakeholder may say, well, you have no basis to make those factual conclusions because you don't actually have the documents that bear on what actually happened, right? So that would include documents that may be located overseas, documents in foreign languages, documents located on a variety of different platforms beyond email inboxes. Those of us who do investigations over here know that employees are not always dumb enough these days to do their dirty work on email platforms. So the question is, what are you doing about messaging platforms like WhatsApp? What are you doing about SMS messages and things like that? That runs you headlong into data privacy issues, which is a separate conversation. We could do a separate masterclass on that, but I flag it because there is a tension between taking all those steps that you need to take to do a credible investigation and preserving your employees and agents and third parties' data privacy rights as well. So second, what does DOJ expect you to do? DOJ expects that companies are going to focus on the conduct of individuals who may have been involved in the wrongdoing, no matter how high in the organization that goes. So that means that you cannot set up an investigation to basically insulate the CEO and the C-suite from wrongdoing. You have to go to the top of the shop and you have to follow the facts as you will. So for example, In DOJ's FCPA corporate enforcement policy, DOJ says that in order to get credit for quote unquote full cooperation, a company has to disclose quote all facts related to involvement in the criminal activity by the company's officers or employees or agents. So no one is safe. And that creates an issue at the outset of an investigation where one has to ask the question is, if you think that the CEO or the CFO or other members of the C-suite to whom a GC or other members of the investigation team would have a direct reporting line, is the investigation going to be sufficiently independent, or is it going to be influenced by those managers or directors or officers in a way that is going to lead the regulators to conclude that the investigation is not credible? So I think that's another sort of gating issue that you really have to think about. And then third, DOJ expects to see remediation to address compliance failures. That means conducting things like what we call a root cause analysis of the underlying causes of the conduct, taking appropriate disciplinary action, making enhancements to controls and policies and procedures to prevent the recurrence of the misconduct. Now, I talked about a root cause analysis, and we've written an article on this, which I'm happy to share. But I would note that in terms of the root cause analysis, it may sound like the investigation, but it's not. DOJ does not view a factual investigation that is focused on the underlying misconduct as the same thing as a root cause analysis. Instead, root cause analysis goes beyond the immediate proximate causes of wrongdoing to explore deeper systemic or cultural issues that may have allowed or encouraged misconduct to occur. So are your people in a particular country being pressured by the business to perform in a certain way? And is that causing them to make the wrong decisions when it comes to compliance risk? That's the type of thing that you have to really explore more deeply in a root cause analysis. And DOJ expects not only that companies are going to perform those analyses and that they're going to perform them with rigor and honesty, but actually that they document them, that they write down the results of those. So I think that's another really important point in terms of best practices. And that's a practice that really has emerged in the past 4 or 5 years from guidance from the U.S. Department of Justice. And we see it live in matters that we handle in front of DOJ, where they expect really robust analysis and they expect something on paper that you can show to demonstrate that you've done that work.
Thank you, Ben. Thank you, Ben, for your insights. I mean, you've discussed, the when, in terms of when an internal investigation can be avoided. I'd like us to discuss the how next. And my next question is for both Olukayode and Cameron. And I'll start with Cameron. When I say let's discuss the how, we started this session by talking about what's been happening in the past 18 months, what the level of activity we've been seeing, and how we've been able to navigate these times. So I'd like you to share with us, given your status as a compliance professional, your experience conducting internal investigations given the new normal. Specifically, can you discuss, things like employees' rights during the course of an internal investigation, and what an employer must know even before the investigation process commences? Also, I'd like you to share how you think the entire process should be structured, given that most of the work is now being done virtually. Cameron?
Yeah, so again, I think going back to my first point, I think we were all a little bit, didn't know how it was going to work in the beginning. How are you going to do an investigation where you can't go collect documents, you can't go interview someone? And I think we've adapted. So I've been, I think when the sort of pandemic struck, we were sort of halfway through an investigation or coming to the end of one, and or you had already done some of the preliminary work. So it took some time before brand new investigations came in, and you could actually do it from start to finish and take into account all of those things that you've mentioned, and Ben alluded to some of them as well, the difficulty in obtaining documents, and how do you deal with if someone's got a company phone and they're sitting in Cape Town and I'm in Johannesburg, it's 2,000 kilometers away. I won't have time to get that phone and get those WhatsApp messages if I'm entitled to them. So those sorts of things are all issues we've had to kind of navigate and figure ways around. And it's not perfect. Sometimes you have to make do with what chips you dealt. And so if you're only able to get the emails off Mimecast and not the computer laptop, because someone is out of the country, or your movement is restricted, etc., then that's the kind of compromise you have to make. So I think there's been a bit of give and take in terms of the pros and cons to conducting investigations under these circumstances. So as I mentioned, it's difficult to, sometimes you won't know what source documents are created on a computer. They just subsequently fell in the swimming pool because someone decided that it was better off down there than when you came and collected it from their house. But on the contrary, on the other hand, we've recently done an investigation where we've had the majority of the issue down here in South Africa, but another party involved, an individual implicated in the UK, and we're able to call on one of my partners in the UK and get in a room with the person that we're dealing with on that end. And that's the kind of thing that, just although it was possible before, it wasn't so normal that it would be accepted. So from that perspective, it's been really useful that we've all adapted to this kind of global virtual sort of process where we can I can dial into an interview in London. That individual's lawyer was present, we were present, our client was present, and we're able to conduct it as if we were all sitting together here. And I just think it would have been a far more complex and complicated process to try and convince someone to go through 18 months ago. So I think that's a positive, and that's one of the, I guess, the pros that's arisen from this. And as I mentioned, there are other issues, practical issues, which create other difficulties. But on the whole, I think we are adapting, and we're getting to a place where we're moving with it. Again, there are data privacy issues and processing issues and transfer of data issues, etc., which create a whole different set of concerns that you've got to look at. When it comes to employees, rights, I think one thing that we need to bear in mind is that this is not a normal situation to be in. So I think the issue of mental health is a real thing, and so you've got to be mindful of when you are potentially approaching someone with a difficult question or a difficult situation, of what position they're in and that type of thing. So I think in terms of employees' rights and just being sensitive to employees, and what they're going through is an issue we probably it wasn't as front of mind as I think it is now. But again, some things are easier. Someone will say, particularly when dealing with government, you would try and schedule an interview with someone. They would say, well, I'm on leave for 2 weeks, and that would be a crucial point of your investigation. And they would coincidentally be on holiday, and you weren't able to move things forward. Now it's far less harder to do that, because you say, well, we'll just need half an hour on a Teams call with you. So again, the swings and roundabouts of this whole sort of last 18 months that we've been going through. I'm still on the fence as to whether on the whole it's been positive or negative. I do hope we can stop wearing masks and go out and see people more often. But I do hope that some of the other things stay the same. I hope that we will still be able to have interviews with people in foreign countries as easily as we are now. I think that's definitely one of the things.
Thanks, Cameron. I'm on the fence with you on that as well. Olukayode, so can you contribute to this specific subject? What are employees' rights in the course of an internal investigations, and what should employers bear in mind before commencing the process?
Okay, so in Nigeria, I think the most important thing is to give the employee and the opportunity of being heard. If the employee is not given the opportunity of being heard, it is likely that the National Industrial Court may set aside the internal investigation or the investigation report in itself. So, for instance, in a case, a very interesting case that came up before the National Industrial Court involving a former employee, Ejike Maduka, against Microsoft Nigeria and Microsoft Corporation. So what had happened in that case was that the employee was the employment of the employee was terminated, and then she went to court to complain that she had been a victim of sexual harassment, and that she had lodged several complaints with Microsoft Nigeria and Microsoft Corporation, and nothing was done. And then she was terminated as a result of that, and as a result of our union activities. So in that case, even though Microsoft Corporation had said, oh, well, when she reported, we conducted investigation, but and then we found that there was nothing there was no substance in the allegation. Now, one of the things the judge in finding Microsoft Nigeria and Microsoft Corporation liable for the conduct of this country manager, one of the things the court had said was that there was no evidence before the court that the employee was invited or interviewed by Microsoft Corporation. So that means that, you know, it is important to give the employee the right, the opportunity of being heard. But the standard of fair hearing required is not the constitutional standard of fair hearing, you know, except the Code of Employment provides otherwise. For instance, in conducting internal investigation, we've had employees ask us, do we have the right to bring a counsel, for instance? Can we be represented by counsel? And we say no, because it is not part of your contract of employment that you have to be represented in an internal process carried out by the employer. So, but I should also mention that fair hearing itself is not a basis, for instance, to set aside the termination of an employee in a simple master-servant relationship. So that is the sort of the rights that employees and employers have when it comes to internal investigation in Nigeria. Adela, I think you are muted.
Thank you, Olukayode. I was saying that my next question is for Katie. I know we've had some, you know, we've briefly touched on the subject of data privacy and data protection, and I'd like you to briefly discuss this. My specific question is around processing information in the context of an internal investigation. What measures do you think an institution should put in place in order to guarantee data protection? How can an organization ensure that is prevention of data leak when conducting investigation? And what do they need to do? What do these organizations need to do to reinforce confidentiality obligations that employees are bound by?
Yeah, I think those are great questions, and data and all aspects of data. The challenges of data have been brought to the fore by the pandemic, as we've all been discussing. And before I get into data protection, just picking up on some of the earlier comments about data preservation, just while I'm on the subject of data generally, which is that, you know, I completely agree that data preservation is critical in the investigations and compliance context. And also observing that, so practically speaking, I think this is a moment when a lot of organizations are making changes to their technological platform, to their data platform, not necessarily because of legal concerns, but simply because of the ongoing conduct of business concerns. And so there's a real benefit to compliance professionals thinking about what that new data landscape looks like internally within the organization or for their clients. And then, you know, trying to make sure that the long-standing principles of, you know, preservation sort of are mapped correctly onto those changes. A number of my clients are currently going through either, you know, technological upgrades or some data rationalization processes, which genuinely are being driven by, you know, the pandemic or business needs. So just when we think about data, that landscape is also changing. Going to your more specific question about data protection and then how you protect that data once you've preserved it, right? And then once you have a need to actually look at some of it, a subset of it, in the context of an internal investigation. Unfortunately, because I don't have a week and a half, I can't sit here and recite all the different data protection rules that are applicable in every country. So I guess probably three principles that I would say. One is that actually it's an incredibly diverse and complex field of law. And so it is actually very important to make sure that you understand the local rules that govern data in the place where you are investigating, as well as the place in which you're reviewing the data and the place in which your client happens to be. Those three places may be very different. And there are some surprising locations which do have quite strict data protection regimes. India comes to mind as one where people might not immediately realize that they have quite strict data protection regimes. So just to be mindful of the jurisdictions that are touching and concerning your investigation, because there is such a diversity. The second point is that there's a lot of focus in seeking that data about ensuring that there are protections, which is of course the whole point, right? Ensuring that protections are respected. And so a lot of the discussion is, what do we do when we are moving data from a jurisdiction that has a higher degree of protection into a jurisdiction with a lower degree of protection? And the focus is on, how can you do that? What contractual mechanisms do you have to have in place? What technical mechanisms do you have in place to make sure that the data is protected? I think potentially too little attention is given to the other side, which is what happens when you're moving data from a lower data protection jurisdiction into a higher data protection jurisdiction. Not that creates risk of data loss, but it can create new obligations. GDPR and UK GDPR are quite wide-ranging in terms of the data protection obligations that they impose, including on people whose data become subject to the EU jurisdiction, even if those individuals are otherwise located, say South Africa or Nigeria. That sort of brings it into the ambit of GDPR jurisdiction. So just to be conscious of the obligations that you're incurring by moving data the other way. And finally, just a proportionality piece, which is, again, without trying to comment on any specific law, sort of as a rule of thumb, be smart about the data that you're collecting for the investigation and conscious about the principle of proportionality. Does this data seem like something that you reasonably need to access? Do you reasonably need to preserve it? And then do you reasonably need to access it and look at it? If so, who is looking at it? Who has access to it? And thinking, is that proportionate to the allegation and to the commensurate sort of potential invasion of privacy rights of the individual? So just always to have that practical question in your head of, okay, do I need to collect this person's entire email collection or entire mobile phone? Or, is there a way of targeting it in an efficient way? That just touches on the data piece. So, and I'm conscious of time. So I have lots of thoughts on a number of other topics, but why don't I just stop there, Adiola, and hand back to you.
Thank you, Katie. So I think I would like us to now to also discuss the process of an investigation itself in terms of how to constitute an investigations panel, for example. When Ben was speaking about best practices from the DOJ process point of view, he did talk about how to ensure that there isn't conflict. If, for example, an investigation was on the CEO of an institution, and how other senior personnel, such as the general counsel, etc., can ensure that conflict concerns are eliminated or mitigated. So picking up on that, I would like Cameron to please tell us who his views on who the ideal members of a company's investigations team or committee should be, and how an institution can ensure that there's no bias on the team. What specific measures do you think an institution should adopt in order to prevent retaliation? Because retaliation, even we as advisors, Olukayede and I, receive questions a lot from some of the multinational clients that we provide legal services to, on whether there is a risk of retaliation following an internal investigation. So I'd like you to please discuss that, Cameron.
So, I mean, I think my first comment would be that there's no one size fits all. And, you know, it goes to, I think what Ben said earlier, it depends who's being investigated. So if it's, you know, someone in the C-suite, it's an executive, then you ordinarily wouldn't, you know, have the CEO of the company or another executive close to them instructing you. So you'd maybe use someone from the audit committee or the, you know, the general counsel or someone, you know, in the compliance role. So it would depend on, you know, who is going to be implicated. If it's someone on the board, then there's a, you know, difficulty from a reporting point of view. So I guess it's assumed that it's not one of your senior executives then, and it's not someone in your audit function or compliance or legal function. Then I'd have all of those, you know, the usual suspects in that team. The one thing I would you know, say is that if there is any concern about you know, bias or interference or something, then, you know, as much as it pains clients to instruct lawyers and pay them fees, I would say that you know, it might be, and we often get asked, you know, some of our clients have a huge, very sophisticated and very you know, strong internal investigations capacity, and they come to us and say, look, for this one, we're going to take it outside so that there's no question that the findings that are made are not made by anyone with us inside our organization, and there can be no finger pointing as to and of course, you can't guarantee that your external service providers can be completely independent and not biased, but it certainly mitigates that risk if you do refer a sensitive, particularly something that's sensitive or that involves people in the higher levels of the company, that it might make sense to refer that externally. And so those would be my sort of 2 points. If it's, you know, you'll need to judge who's involved and sort of try and work out a way to insulate the investigation panel or committee or, you know, the instructing team from those who are implicated. The second point about, you know, protecting people from retaliation, and I think, you know, blowing the whistle in the UK or the US is different to blowing the whistle in South Africa and Nigeria. They're very different considerations to make. So I think, you know, the first thing you should do is at a policy level, you know, your employees need to know that at least internally, you know, the policy states that they're encouraged to do it, they're protected if they do blow the whistle, and they won't be impacted. In South Africa, they call it, they won't suffer occupational detriment, but essentially they won't, you know, be at risk of losing their job or being demoted or not being promoted or salary not adjusted, etc. So they need to feel comfortable that there's a mechanism for them to come forward and do it at least at a policy level. But obviously that only goes so far as the paper that it's written on. At a more practical level, confidentiality is key, you know, to giving people the comfort to speak up. So if they know that if they are to come forward, that what they tell you is going to be kept confidential, it's going to be limited insofar as it's distributed within the company to the extent that it's possible, you know, that it can be anonymized, that would help as well. Just to give the employees the comfort that, you know, to make them feel that they are not going to be putting themselves at risk by coming forward. So taking practical steps like that, you know, would obviously help in mitigating the risk of retaliation. So, you know, I'd say there's 2 steps. One is on a policy level, at least have it set in, you know, in writing that that they are protected, you know, and then practically, you know, you've got to take any other steps you can to do that as well. So those would be I know we're short on time. Those would be my quick fire answers.
Thanks. Ben, would you like to contribute to that specific subject?
Yeah,
what are your views here?
Just really quickly. I mean,
Sure.
Cameron knows this from being in South Africa. I mean, there was an employee in an auditing function in a government entity a couple of weeks ago that was a witness in a PPE fraud case who was murdered. And the reality is that no policy, as Cameron said, is going to make employees safe. And I think that what's really incumbent upon us as compliance professionals who are encouraging employees to come forward. And it's really the lifeblood of information that allows us to help do our jobs, is to sort of think about those security risks first and foremost as we're doing investigations, as we're setting up whistleblowing hotlines. There's not an obligation under South African or Nigerian or US law to protect the life and limb of whistleblowers. But if you don't do it, you're never going to get sufficient information. And I think that if you're sitting across the table from someone in a training or whatever it is, and I remember just having this experience the first time I came to do work in Africa and hearing from people across the table saying, like, look, you don't understand, like, this is not something where we can simply come forward. And I think that we as compliance professionals need to show leadership on that. And we need to have discussions, open and candid discussions about those types of risks, and not make people feel as if they're not doing the right thing if they feel unsafe. Because the reality is that where, Cameron and I live in Johannesburg is very different from where rank and file employees who may have the goods to report something, on a really important matter, where they live, where they go to church, and the sort of, and there are also, there's another part of this, I think, and this is particularly the case in South Africa. There's a cultural aspect to being a whistleblower or an informer that I think people need to recognize, so that if you're someone who snitches on people that are above you, is that something that's going to not only cause occupational detriment, but cause you to lose, standing in your community and things like that. And I think that we need to have honest conversations about these issues. I think as compliance professionals, we need to try to sort of risk assess security risks up front, and we need to have policies and procedures around those. So when you take in a new whistleblower complaint, are you saying to yourself, in every circumstance, is there a security risk around this, and how do we try to mitigate that? So I think it's just really important, and it's the reality of doing business on the ground. And it's not just South Africa and Nigeria. I mean, this is true in Kenya. It's true in a lot of places in sub-Saharan Africa. And so it's just it's an occupational hazard. The other thing I would say is it's not just about whistleblowers. It's also about compliance professionals. The line audit people, the line compliance professionals that are out there doing the dirty work of the company to make sure that the company is complying, their lives are at risk too. I mean, it is something that I think we just need to focus on as a compliance community.
I agree with you, Ben, totally. And I've heard it, I've had some employees raise that concern as well. So you're absolutely right. Katie, would you like to contribute to this issue?
I guess picking up on the whistleblower point, I just, I completely agree about how important it is to focus on the safety and security first of those individuals, particularly in a remote working environment, right? I mean, unquestionably. And I think that actually the focus on whistleblowers, I mean, that's sort of the starting point, the bedrock, right? The safety and the security, the physical security, right? But sort of, in addition, I think that focus then has a really positive effect on the conduct of the investigation, and then sort of looking ahead to the other focus of this panel, right? The reputation management aspect that the company is having to navigate as a result. So, thinking about that connection, I mean, I think that the best investment, well, not the best in every, it will depend on the case by case, but often a very good investment that a company can make in managing its reputational risk is managing its whistleblower treatment, and really making sure that, people who raise complaints, are heard, are treated, fairly appropriately, humanely, as well as anybody else who then is in contact with that investigation process, as witnesses, as people who are supporting the investigation, as people who are contributing to it, because I think it's the reputational risk in today's sort of very connected environment isn't solely about sort of a journalist coming in and then publishing a huge expose, or some major scandal hitting the front pages, or it starts with what's going on inside your organization and what people are speaking about, and whether people are disgruntled or respectful of the investigation process itself, and respectful that they are being treated well within that process. So I think when it comes to encouraging complaints, but also protecting reputation, making sure that you're investing in protecting whistleblowers, in protecting, witnesses and others involved is really a crucial step. Interestingly, and just thinking about what's different in the pandemic, one interesting sort of positive impact that I've seen of the pandemic is when you are when you're handling an investigation. I'm sorry, can people hear me? Because I've just gotten a
We can hear you.
signal on my internet. Can you hear me?
We can hear you. Go ahead.
Yes, wonderful. Okay. That one I think positive benefit. One is that it actually can dampen the kind of gossip and rumor that can be very harmful to teams and to individuals who are interested in helping and supporting an investigation. Because often the people of the team that you are investigating, they're sitting near one another. They see one another go into offices to, have interviews, or they're called down and you have to, set up a special room for them to go. And, that sort of orchestration and the potential effect of being worried about talking on the phone with your supervisor standing right next to you, right? That does, fall away to an extent during the pandemic. And I think it can actually, in some respects, make protection of whistleblowers and witnesses in investigations easier. So I don't know if others have had the same experience, but I throw that out as an observation. It's something we shouldn't lose as we move to a more in-person environment.
Thank you. Thank you. I will move on to Nigeria specifically now. And I would like Olukayode to share his views on one of the current trends that we are seeing. It appears that more Nigerian companies are beginning to embrace internal investigations as an integral part of their ethics and compliance program. This wasn't as common previously. So Olukayode, can you tell us what you think is responsible for this laudable trend? Is it the case that there is any law in Nigeria that compels companies to carry out internal investigations, particularly in the context of employee misconduct, or what do you think is the reason for this?
Okay, well, it is true that more companies are beginning to embrace internal investigations as an integral part of their ethics and compliance program. It is difficult to list all the factors that may be responsible for this. But one thing that is clear is that companies in Nigeria are becoming more aware that investigating wrongdoings by directors, employees, and then implementing remedial measures, if necessary, is key to maintaining reputation. And indeed, ensuring maintaining your reputation is a way to ensure continuous profitability. Now, in terms of whether there is a law that compels companies to undertake internal investigations, there is no law in Nigeria that mandates companies to do so. However, carrying out an internal investigation in the case of an employee misconduct is really one of the effective means by which a company may avoid being liable for the employee misconduct. And I just gave an example of the Ejike case, for instance. One of the major reasons the judge cited in that case for holding Microsoft Nigeria and Microsoft Corporation liable was because there was no investigation whatsoever. In fact, the judge also said that there was no investigation report tendered before the court, so nothing was done, even though the claimant in that case had reported misconduct organization. So I think on the basis of that, and that is just one of the several cases in which the National Industrial Court has held employers liable for employee misconduct. So I guess becoming aware of that possibility, companies are now beginning to take internal investigations more seriously in Nigeria, because in order to be able to challenge suit, on the basis of negligence. You know, conducting an internal investigation is one of the ways the company can show that it exhibited the standard of care required of a reasonable employer in similar circumstances. So I think those are the real reasons enforcement has really improved.
Okay, thank you. Picking up on this, if Katie could kindly share her views with us as well from her experience working on across various jurisdictions. So Katie, when a company has undertaken an internal investigation and there is conclusion of culpability, how do you think the organization should navigate any reputational risks? And what are your recommended best practices for implementing any proposed remedial actions, whether in an investigations report or otherwise?
Thanks, Adiola. A couple of headlines, maybe four points to take away. The first is that, as I've already spoken about, I think reputational risk starts with, proper procedural treatment of whistleblowers and participants in the investigation, and a real focus on investing in that area. Because my second headline point is that I think thinking about remedial actions should start at the beginning of the investigation. And although some of the actions will sequentially follow a conclusion, it really shouldn't be at the conclusion that you start thinking about remediation. It should be much earlier in the process. And I think the third point is that in working through what that remediation looks like, it really depends on the nature of the investigation. Of course, individual remediation in respect of particular individuals, whether it's some sort of employment action or otherwise, is one option. But I think that it's not just about actions in respect of individuals and remedial actions in respect of individuals. It's also about organizational and institutional change that can happen as a result. And just to bear in mind that remedial action also encompasses those activities. So for example, if you find that a large number of employees are engaging in low-level T&E fraud, where they're falsifying or not putting in accurate paperwork, yes, those individuals should consider remedial action against those individuals themselves. But actually, when it comes to thinking about the risk for the organization, both prospectively and in the context of a potential government investigation, probably more important will be to fix that system going forward, to figure out why this is happening so frequently, and potentially if there's anything systematically with the process that can change, whether it's automating it or rewriting the rules to make them clearer or reducing the thresholds for reimbursement amounts, these sort of other changes around the process. And I think too often, that step of remediation can be, can lack the focus of the sort of retribution on specific individuals. The fourth headline point, though, is of course individual conduct is remediating individual conduct is, of paramount importance. And actually, from a UK perspective, increasingly an area of focus when it comes to the decisions of judges and the authorities to enter into DPAs in lieu of charges will be the extent to which an organization has engaged in cultural change, which is really a shorthand for have they exited from the organization, anybody who is involved in the misconduct, as well as anybody who was in role overseeing or managing the relevant aspects of the business at the time the conduct occurred, even if they don't have any involvement or they have minimal involvement in the conduct itself. So thinking proactively and consulting with employment specialists, relevant employment specialists early about what conduct, what are the exit opportunities are, it gives you the leeway to negotiate, if appropriate, mutual separation agreements with an employee rather than having to actually terminate them. that may not be the ideal option, but it may be a lot better than getting to the point of losing at an employment tribunal because you're trying to dismiss somebody for an illegal reason. So thinking about those options, early consulting, with the relevant employment teams, I think is critical when you come to thinking about remediation.
Thank you, Kate. Before we'll go to the Q&A chat box shortly, but before we do so, I have a final question for each of Ben and Cameron, starting with Ben. So we've discussed, best practices, how a company can ensure that it eliminates the risk of reputational damage, how to conduct internal investigations efficiently, the process, and how to ensure that whistleblowers' rights are protected. Ben, can you please share with us any risk management strategies that you can suggest for that could help a company to develop reputational resilience ahead of a crisis?
Sure. So I think, it starts with a process point, and I would start by, paraphrasing Churchill, who said something along the lines of never waste a crisis, right? And what does that mean? It means companies in this context should learn from their mistakes to become more resilient to reputational risk. So in practice, it means looking back at decisions that are made in the heat of the moment during a corporate crisis or investigation and asking honest questions about what it could have been done better, what you could have done faster, what steps would have been easier if the company had a playbook in place or specific policies and procedures. In terms of concrete examples where we sometimes see companies fall down is that they're paralyzed when they're faced with allegations that need investigation and quick reaction because they lack policies and procedures on internal investigations. They lack an understanding of the types of data that they can collect quickly and what they can and can't do. They lack an understanding of when they can put an employee on gardening leave and when they can fire an employee immediately because of some misconduct. So when something comes up, no one knows who's in charge, what steps need to be taken around preservation of documents or remedial actions and things like that. So that's why the exercise, I think, of drafting a well thought out investigation plan or a well thought out investigation policy and procedure is really an ounce of prevention that's worth more than a pound of cure. It forces you to think about those issues in advance and to say, what do we do when this kind of thing happens? Because in the heat of the moment, you don't have the chance to figure those things out. To Cameron's point, it's also worth thinking about having a good panel of professional services providers, and this is obviously a self-interested comment. But what we find is that when firms, our clients who have reliable outside counsel and reliable outside forensic providers who can immediately come in, they know the business, they know the people, they know exactly what they need to do immediately. Those, if you do that as opposed to doing an RFP where you have to take in 3 or 4 different people over the course of a week, you're moving faster. And those minutes, those hours, they count. So the other point I would make, and this seems simple, is to focus on good record keeping. And this goes back, but I cannot tell you how many investigations that I've been involved in where, for example, an issue revolves around a particular transaction or a third party, and the company cannot find the key documents. It can't find the contracts with the third party. It can't find the diligence files on the third party. And in crisis situations where those hours count, the company needs reliable information around those types of issues in order to make snap decisions. And again, those types of issues can paralyze the company's ability to act swiftly and decisively. And the last point is just, I think, Katie has hit the nail on the head on this, is sort of don't wait to remediate, go back to remedial action. Too often we see companies that feel as if they have to wait until the end of investigations to take remedial action, when they should be taking remedial measures to sort of stop the bleeding, as it were. That demonstrates to external stakeholders that the company is serious about the issues at hand. It can also help limit the scope of the investigation, because if you cut off a relationship completely with a third party and you can say, we're not doing business with them anymore, then you may decrease the scope of what you have to look at considerably, because you could say immediately, look, we are no longer in business with this entity anymore. We had 5 or 6 transactions with them and then we cut them loose, and we're not having to sort of go through an entire business cycle, looking at what they're doing in real time. And then the last point is just back to what Katie said. Unfortunately, I do think that some regulators look at how many people you fired almost like scalps. They're sort of looking at it and saying, well, in Rolls-Royce, there were 38 people who were fired. What's your number? As if it's sort of a comparison. And I think that while you know, we should never, as compliance professionals, talk lightly about people's jobs, it is an important thing that business people need to understand that this is something that they're going to be judged on. And I would say, to Katie's point, I think, like, at the beginning of an investigation, understanding what the relevant legal frameworks are around employee discipline is hugely important. But I would even go a step further back, and I would say, for people that are in compliance sensitive positions, be thinking about those issues when you bring those people on and you're talking about negotiating employment contracts and you're talking about policies and procedures around employment issues. Because in a lot of the countries in which we operate, I'm from the US, and so, you know, we have at-will employment. It's really easy to hire and fire employees. Katie could agree to this. But when you come to places in EMEA, I always think back to the Italian Parmalat scandal. There were people that were under indictment that could not get fired, and they even had been convicted. And a lot of the markets in which we deal have very protective labor laws like that. And so I think you have to be prepared for those kind of things even before the investigation starts. So I'm sorry I went on long, but I think those are important points.
Indeed, indeed, and they were important points to note. Cameron, what are your thoughts on this? Risk management strategies. Yeah.
From specifically on from a reputational perspective, the one thing that I'm always amazed by is, you know, any lawyer will tell you, don't ask a question you don't know the answer to. And I'd say in an investigations context, don't answer a question you don't know the answer to, because you see in the press, there'll be an allegation in the press that such and such company procured this deal through a corrupt payment, and they'll say, there's no ways we did that. That's completely untrue. And they'll have a press statement, and, you know, and it turns out 6 months later that they've now done the investigation and they did actually do it. And then you can't put the genie back in the bottle in that case, because, you know, you've come out, you've lost all credibility. So, as you know, as much as it pains you to just sort of really feel like you're sort of being punched by everyone on Twitter and in the media, etc., it's worth rather just riding out those, you know, initial hard months when you're really taking a pounding reputationally, until you know your story and you know your facts. And as Ben said, you've by that stage had a chance to put together all your processes in place, cut ties with people you don't want to be doing business with, you know, because there's nothing worse than saying, oh, well, we deny that. And they say, well, you're still paying them because, you know, you still have a contract with them. Rather get through that phase first, understand what you've done and what your risk is. And if it turns out you haven't done it, then you can come forward and say you haven't done it. But that for me is always something I'm always quite shocked by when, and particularly when it's, you know, multinationals who are not necessarily aware of what their subsidiary down in Africa was doing. We've seen that before as well, where they'll come out with a knee-jerk reaction, you know, we've dealt with this, or we don't believe it happened, and it did, and that's a problem. The other thing which I think is really difficult is, to the extent you can resolve something quickly, get it done. So, you know, Siemens is a good example. They took their medicine when they went through their difficult patch, and now they're seen as the sort of poster company for really good compliance. Whereas if it drags out for years and years and years, you're known as the company that's under investigation for X or Y. And unfortunately in Africa, where the wheels of justice don't turn as quickly, you know, there'll be media articles about a company for years and years just because the local law enforcement haven't done anything about it, and the press, you know, are still hammering on about it, and so it stays as this kind of black cloud hovering over them. So to the extent you can, you know, try and push some kind of resolution, obviously not admit anything you didn't do, but to the extent you can finalize something and get moving forward, even if it's, you know, means you have to admit some, you know, that you did do something wrong. And, you know, Rolls-Royce is a good case. When they paid their fine, their share price went up, you know, so it's seen as a good thing. Whereas if it stays hanging over you, you're going to be pegged as this company that's up to no good, or got a scandal hanging over their head. So those are my 2 points. don't rush to an answer and try and get a resolution.
Thanks, Cameron. We have only a few minutes left. I'm conscious of time, and I see that there are a couple of questions here. There is a question here for Cameron and Ben. He says, if an employee is being investigated internally on a claim for financial and procurement fraud, internal investigators have indications that the proceeds of the fraud are in the personal bank account of the employee being investigated. But the employee says he or she does not wish to provide internal investigators with his personal bank account details. Instead, the employee only provided internal investigators with a salary bank account statement in which nothing is found after review. Assuming you're the internal investigators in an organization, what measures will you adopt to obtain the employee's personal account statement, or will you pass on the matter to the government anti-corruption agencies for investigations?
This first stab, and then you can come and save me. I think your options are limited there. Certainly in the South African context, you'll be limited. You won't be able to compel anyone to provide you with their personal bank statements, and I'm pretty sure it's be the same elsewhere. And you can draw an inference from that. You might be able to say, well, that would point to them if they're not prepared to show me their bank statements, and they may be hiding something. It potentially is unfair to do that because I wouldn't want to show my bank statements to anyone either. But there are limits. I don't. Short of in South Africa, you would go to the police, open a case, and request them to subpoena the documents through a 205 subpoena. But that's about as much as you can do in the private sector.
Yeah, no, I think that's exactly right. I mean, I think that you have to understand what your recourse against the employee would be from a labor and employment standpoint. And in the US, we have an old saying is that you have a right not to cooperate, but you don't have a right to remain employed. That's not always the case over here. But I would want to know the answer to that question. And then I think in addition to going to law enforcement is, if one had some evidence of some flow of funds and thought that it might be going to an employee's particular bank account, and one knew the financial institution, one could contact the financial institution directly because they may have an obligation to file a suspicious activity report and things like that. But again, I think as Cameron said, your options are pretty limited in that circumstance.
Thank you. There is a question here for Katie. From your experience, what steps are companies to take to ensure that no litigation arises from internal investigations? And if litigation happens, how can it be managed?
It's a great question. It's a great question because I think there's two different kinds of, well, there's many different kinds of litigation, but there's two different types of litigation that can be related to investigations. There's the avoidable kind and the unavoidable but mitigatable kind. The avoidable kind that I see most often stems from sort of a lack of attention during the investigation to the position of third parties, counterparties, et cetera. So for example, making sure that if you are investigating, if in the course of your investigation, you're gathering data and information from a third party outside the organization, making sure that you understand, that supplier, distributor, whatever their relationship, the contractual relationship between your client and that entity, to make sure that you are giving them whatever notice that you need to give them, or for that matter, are just conscious of the risk that you're taking, in gathering and using that information in the way that you are. That's what I would say is the avoidable kind. Equally, that applies in the employment context. And if you're thinking about, employment litigation or arbitration as a result, making sure that you're conscious of employees' rights in the investigation, whistleblowers' rights in the investigation from the outset, so that you're not, trampling on those and inadvertently creating, litigation risk for yourself. There's then the, potentially unavoidable kind, which is that, there are many cases where if you have a material investigation and you have to make a disclosure about it, there will be some sort of shareholder litigation. Certainly if you have a US exposure, almost as night follows day. And, in that, I think the advice, and it will depend on the context, but, I think the advice there is, to be, cautious about statements that you're making, and also, plan ahead and prepare, because an ounce of preparedness is worth whatever pound of remediation at the end of the day. I'm sure I've messed that up because of the interest of time, but yes, happy to talk about that further. Thanks.
Thank you. Olukayode, there's a question here for you that says, does Nigerian law permit organizations to carry out investigations in the sense of the Nigerian EFCC or SFU? If not, to what extent is it permissible to carry out an investigation, or should it be called an inquiry instead?
That's a very interesting question. And I don't know, I think that whether you call it an inquiry or an investigation, in fact, an inquiry itself is an investigation. It's just a nomenclature. But just to add that what you do when you carry out an internal investigation is different from what the EFCC or the SFU, which stands for the Special Fraud Unit of the Nigeria Police, does when they carry out investigations. So a company carries out internal investigation to as a fact-finding measure to find out what actually happened, and in order to implement remedial measures if necessary. The EFCC and the SFU carry out investigations with a view to finding an offense and prosecuting the offender if necessary. And just to say, for want of better analogy, carrying out an internal investigation is not different from you trying to find out the source of rainwater leak into your bedroom. So, and then a company, there is an issue, a company wants to find out what has gone on, so the company is entitled to carry out an internal investigation. And as I mentioned, there have been several cases in which the National Industrial Court had relied on or admitted reports of internal investigations carried out by organizations.
Okay,
I hope that answers your question.
Yes, it does. Thank you. I'll take one more question before we close. There's a question here on whistleblowing, and it says one of the biggest challenges is getting the balance right between protecting a whistleblower, high anonymity, and assuaging the feelings of an investigated or innocent employee who is asking for punishment against the anonymous whistleblower. Also, being able to distinguish between when a whistleblower acted genuinely based on suspicion and when a whistleblower was really out to make life difficult for another. What are your views? Would anybody like to take that question?
I think there are those times when whistleblowing mechanisms are abused. We, a couple of years ago, had an instance where the chairperson of a board was getting a different whistleblowing complaint against them every 2 weeks, and do an investigation, find it to have no merit, only for another complaint to come through, and it just kept repeating itself. And eventually, the board had to take a decision that there's been 5 or 6 whistleblowing allegations against this person with no merit. What are they going to do about it? So I think that is something that happens, and it's unfortunate, but unfortunately you do have to go through the process. But at some point you will probably take a stand and realize that it is being abused. So that's just a personal sort of anecdote that I've experienced previously. And I think we've also you often get people who blow the whistle saying, well, you need to give me the feedback now. And that's an important compliance piece, which is, it's not their right to have. They've made a complaint. They're not the board. They're not the council. It's not their privilege that they will be waiving if it's given to them. So that's another important piece to manage, is that the whistleblower is not necessarily entitled to know what's going to happen to the person that they blew the whistle against.
Thank you.
I was going to say the same thing, and just having that expectation set out clearly in writing. Whatever the position, it may vary from place to place and country to country. Having the expectations of what information they are and are not likely to get as a whistleblower. If you could point point to something that pre-existed the investigation and say, this is just policy. Sorry, can't tell you anything. Yeah, I see that work very successfully. Sorry, can't tell you anything, can't tell you what this is about, can't report back to you. That's our standard process. And at least, people might not be happy about that, but at least they can see it's fair.
So sorry, Adela, if I may,
Sure.
I think that it is almost impossible to prevent whistleblowers, some whistleblowers, from using the whistleblowing system for their selfish reasons. It's almost impossible, and that's the essence of having to first sort through the reports as they come in. Because when there has been a report, you first have to ask yourself whether that allegation is even possible in the first place. So if it's not possible in the first place, then there's no point going further. But even then, if you have to then investigate, that is why it is very important to treat an investigation as a fact-finding mission as opposed to an adversarial mission from the beginning. And that's why it's good to maintain confidentiality, not just of the whistleblower, but of the target of the investigation. So all of those things have to be put in place just to guard against having to, soil the name of the target company-wide when there is no substance to the investigation. And that's what we try to do when we conduct investigations following a whistleblower complaint.
Thank you very much. You could see from the discussion so far that we could go on and on. This has been a very interesting session. I'd like to thank each of you, Ben, Cameron, Katie, and Olukayode, for your time this afternoon. We've had an interesting session. We've discussed the consequences for corporate reputation if an organization doesn't take an investigation seriously. We've discussed best practices as well, how to ensure that data privacy risks are eliminated or mitigated. We've also discussed how best to undertake an investigation in the new norm and in the context of having to undertake virtual interviews and review documents virtually. What best practices are in that light as well. I'd like to thank each and every one of you for your time this afternoon, and to thank our audience as well for staying with us throughout this session. It's been quite engaging, and I'm sure that we've all had a few takeaways. Thank you, everyone, and bye-bye. See you some other time.